limitations on our legal system. And today I'm going to focus on the constitutional side, but as some of you probably have explored in the past, this occurs in statutory law all the time, right? So we face questions about whether our environmental laws, our labor laws, our antitrust laws, et cetera, do they extend beyond our borders to activities that occur abroad but have effects on the United States? So it's a more general kind of question about geographic limitations. Constitutionally, this question has arisen in many different contexts throughout American history. So Dred Scott was in part about, does the Constitution reach into areas that are not the state? So at the time it had to do with the territories that were held. They were clearly within the sovereign sphere of the United States, but does the Constitution's due process clauses and property clauses, et cetera, apply there, or do they have to be extended by Congress, right? So this has arisen in many different instances. So it's not a new issue, but I think this is probably obvious. It's a much more important issue today, or a much more salient issue today, because of Guantanamo. So the problem of... That's okay. The questions about Guantanamo really are, in many ways, questions about the Bill of Rights and the geographic restrictions on the Bill of Rights. Likewise, what's been in the papers the last week or so about CIA prisons being located in other countries, in part address these issues of, well, why does the CIA want to put these prisons in other countries? Well, one reason is they want to keep them out of the reach of American courts, and they believe that U.S. law would apply if those prisons were cited within the U.S., and they think that they don't apply if they're cited in Romania or wherever they happen to be. It seems to be Poland and other places like that. So in any event, it's something that's been in the news. But let me just point out more mundane ways in which this issue arises. So the FBI frequently engages in policing abroad. They go and they interrogate suspects abroad, sometimes related to terrorism, post 9/11, but related to a whole set of issues, money laundering, et cetera, drug trafficking. Likewise, the Drug Enforcement Agency. The New York City Police Department has, I think, a half dozen or a dozen police officers permanently stationed in cities abroad in order to both deal with terrorism-related problems, but also other organized crime that affects New York City. I think there are some other major cities that do this. I don't think LA does it. I think Chicago might have a couple. But New York's been the most aggressive in this. So there's a lot of policing that's occurring outside of our borders. And of course, related to drug trafficking, we've been doing this for a long time in South America and Latin America. So in all these cases, there's a question about what kind of legal restraints does the FBI or the DEA or the New York City Police Department face when they operate abroad. And again, these are all ways in which we think about geography. Okay, so what I'm going to do today is just talk a little bit about some history, how we thought about this, and then talk about three possible approaches to thinking about the question of the Bill of Rights and where it applies. And I'm going to make the case that we should think pragmatically and functionally about where the Bill of Rights ends, rather than think the way most of our court cases have come down, which is to say the Bill of Rights for aliens ends at the border. Right? So the doctrinal answer to the question that I pose is actually pretty simple. It's that if you're an American citizen, the Bill of Rights follows you around like a little halo wherever you go. And so vis-a-vis the US government, of course. So you're protected. As a citizen, I am protected wherever I go. So if I'm searched by an FBI agent abroad, I can invoke my Fourth Amendment rights, my Fifth Amendment rights, et cetera, if I'm interrogated. But for those of you who are not, so how many non-citizens are here? Okay, so a few of you. You lose all those rights the second you step outside the United States. While you're here, though, you receive them. So we've traditionally had the view that aliens who are here in the United States are treated essentially the same as citizens for virtually everything related to the Bill of Rights, right? You can be deported, but you can't be, the Eighth Amendment applies in the same way, et cetera, et cetera. But once you leave, that ends. Okay, so that's the doctrinal answer. But I'm going to argue that that doctrinal answer doesn't make any sense. Okay, so a little bit about history. Traditionally, if you think about the 19th century, the US, the position of the US, and this is the position of most countries, was that legal systems and legal rules could not extend beyond sovereign borders. And that was grounded in a vision about how sovereignty worked, right? So the idea was that states were territorial entities, and sovereigns could not intrude into another sovereign's domain. So in other words, if we were to say that our laws apply in some way in Mexico, that would be intruding into Mexican sovereignty, and that was bad, right? So we tended to have this view that the Constitution and statutory laws were limited by the borders of the US. So for example, in 1880, well, let me back up for a second. We had this view vis-a-vis other sovereign states. So in the 19th century, there was a concept of civilized states, the standard of civilization. And the notion was that some states were civilized, i.e. European states, the United States, a few others, and that for those states, they were sovereign and we treated them in the way that I just described. For states that were viewed as uncivilized, Japan, China, Turkey, Morocco, basically non-Western states, then a different set of rules applied. And so one of the things we did for these, quote, uncivilized states was we would create, we in the West would create what are called extraterritorial courts. So when traders were in China or Japan in the 19th century, and let's say you and I were there and maybe I killed you or something, then I would not, as an American citizen, and you as an American victim, or if there was a tort to make it less dramatic, we wouldn't go before a Chinese court. We deal with it through this American court. And in fact, for a while, we had a U.S. District Court for China, an answer to the Ninth Circuit. And that lasted until the 1930s. So we have these extraterritorial or consular courts in uncivilized countries. So in 1880 in Japan, where we had these courts, had this exact murder scenario. A guy kills another guy, a sailor kills another sailor, and they go before the consular court, and the murderer gets convicted, sentenced to death, and appeals to the Supreme Court saying that his Sixth Amendment right to trial by jury was denied. And the Supreme Court says, you don't have a Sixth Amendment right to trial by jury. You're outside the U.S., and they specifically say the Constitution can have no operation in another country. So the whole idea that you have any Sixth Amendment right, forget it. Right? It doesn't apply because you're in Japan. And this verdict was rendered in Japan. So that kind of encapsulates, that case, Ross v. McIntyre, kind of encapsulates this 19th century vision that Bill of Rights clearly ends at the border. Now, that said, we faced, as Dred Scott suggests, more complicated questions within the U.S. itself. Right? So we understood that there was a sovereign kind of sphere that the U.S. operated in. So take California before it became a state, or Hawaii. Hawaii was a territory until 1957. We acquired Hawaii in 1996 or something like that. So for decades, Hawaii was ruled by the federal government, in essence, as a territory, not as a state. So did the Bill of Rights apply there? And the answer was sort of. Right? And so the insular cases were all about this new imperial set of entities that the U.S. acquired after the Spanish-American War. Puerto Rico, this is still the case today. Puerto Rico is clearly sovereign U.S. territory vis-a-vis other states in the international system. It's an American place, but it's not a state. And the question of how the Bill of Rights applies there is complicated, and the answer seems to be it's not quite the same way. Right? So fundamental rights apply, other rights apply by statute, but the Constitution operates differently. So the point is just to say we had a kind of ambiguity from the beginning about how this worked. But when it came to leaving the U.S. and dealing with another country's territory, it was clear that the Constitution did not apply. Okay, so again, this idea was grounded in the international law of the time, which said that states are territorial, what we might call Westphalian sovereignty. And it was, moreover, considered to be dangerous to do the sort of thing that I'm discussing, to say that constitutional rights somehow move beyond, because the world was viewed as kind of anarchic and dangerous. And you see these sort of sentiments in the cases of the time. Okay, so that's sort of the late 19th century. And as I mentioned before, same thing for statutes. We generally thought that they did not, for the same principles, did not apply beyond our borders. Okay, so 20th century, things start to change. Right? So in terms of statutory law, courts increasingly started to say, well, maybe our statutes do apply outside our borders. Right? So crimes that occur or that are conspiracies perhaps that are made abroad but carried out here, well, maybe we can go after some of the part that happened abroad. Antitrust is one of the big areas where this happens. So the courts start to say, well, if you have a cartel and the cartel is operating abroad, but they're having effects on American markets, well, we should be able to go after them too. So we start to do that. And after 1945, we start to do that a lot. And so we still have, as a doctrinal matter, a presumption against extraterritoriality. So courts will say, if Congress does not say what it intends to be the geographic reach of this particular statute, we'll assume that it only operates within the U.S. unless there's some reason to believe otherwise, and the cases are kind of all over the map. But the important point is we no longer have this strict territorial view. So what about the Bill of Rights? Well, starting in 1957, we changed our view about citizens, right? So Ross v. McIntyre involved a citizen, and the court was emphatic. Citizens have no constitutional rights abroad, just like aliens. So in other words, citizens and aliens are treated the same. In 1957, you get the same kind of fact pattern. You get a murder, in this case by a woman who's married to an Air Force officer. She kills her husband. She's tried by a court-martial, which was the way we handled crimes involving dependents of our military forces. And again, not the same trial by jury, different rules. She appeals, goes to the Supreme Court. The government argues, we decided this 60 years ago in Ross v. McIntyre. Doesn't matter, you don't have any Sixth Amendment right because it took place in England. But the Supreme Court rejects that and overturns Ross and says, actually, the Constitution applies wherever a citizen goes. And just because they happen to be abroad doesn't make a difference. Right? So that's a big change. That's a very big change. And in the same case, they cast doubt on the insular cases, which were generally viewed as holding that the Constitution follows the flag, i.e. to Puerto Rico or to Guam or to the Philippines or any of our other colonies, but doesn't really apply in the same way. Right? And they said that's also a dubious idea, but they don't overrule it explicitly. Okay, so in the wake of Reed v. Covert in 1957, you start to see lower courts occasionally arguing that aliens abroad also have constitutional rights. And given the logic of Reed, that's understandable, right? But then in 1990, the Supreme Court faces this decision specifically in a case called Verdugo, and the issue there is the Fourth Amendment. Does the Fourth Amendment apply to essentially the scenario I started with, DEA agents searching a house of a Mexican drug trafficker in Mexico? But he's tried, obviously, in the US, and he happens to be in the United States at the time of the search. And they say, no, the Fourth Amendment does not apply to him because he's not one of the people, right? So the language of the Fourth Amendment is the people shall be free in their homes, or whatever the exact wordage is, but they use the phrase the people, the framers did. And this is Rehnquist writing the opinion, says, well, a foreigner is not one of the people. Right, that this is meant to reach. So the fact that the Bill of Rights is written not in terms of citizens, but in terms of persons, typically, or the accused, or the people, doesn't mean it applies to everybody. So they say, no, Fourth Amendment doesn't apply there. So in the wake of that decision, then we see lower courts retreat, and they stop, not that there were so many instances in which they held that aliens had constitutional rights abroad, but that pretty much comes to an end. Given the logic of that, it's not surprising that I think as last year or the year before, a court in Utah held that an illegal alien here in the US also didn't have Fourth Amendment rights on the theory that he had apparently come in, been deported, came back again, this time was arrested, again searched without a warrant, and his lawyer tried to bring a Fourth Amendment claim, and the district court said, you're not one of the people either, right, on the same kind of logic. So once you go down this road, you can expect a lot more of these kinds of cases. And it raises this issue about, well, how is the Bill of Rights supposed to operate generally? Is it about membership, citizenship, or is it about where you are? And if it's about where you are, then why did it matter in Verdugo that his property was abroad? Shouldn't the important issue be where he is? So in that particular case, when the search occurred, he was in a jail in San Diego, but his property was in Mexico. If it had been the other way around, undoubtedly the court would have held that the Fourth Amendment applied. So that conceptually doesn't make any sense. It's more important where the property is and more important where the person is. And so the point of this is to say that as the 20th century goes on, the cases get more and more confused. Right? So what's the underlying theory becomes very hard to discern. Do we care about membership? Do we care about location? If we care about location, why, et cetera. So we get a much more confused set of answers. So then along comes 9/11 and Guantanamo and so forth, the occupation of Iraq, and the issue arises again. And the question is, in Guantanamo, do the detainees, putting aside their status as potential enemy combatants, do they have any constitutional rights at all? And the administration, again, has been very clear in saying that they have none. They have none. It doesn't matter whether they're in Guantanamo or not. The point is they're out of the US. So part of the debate in Guantanamo has been, well, where is Guantanamo? Is it really a foreign country, which is a kind of dubious proposition? Or is it something that's kind of quasi-American in the same way that Puerto Rico is quasi-American? Are they similar in this way? But that's a kind of different issue, right? If you took the detainees and moved them to Bagram Air Base in Afghanistan or Iraq, I can't remember where it is, then same question would arise. Do they have any constitutional rights? And the answer from the Bush administration would be no. And if you take that idea seriously, it suggests a lot of, I think, hard to believe conclusions. So for example, when we occupied Iraq, was the Coalition Provisional Authority bound in any way by the Constitution? It would seem to be that the answer is no. So in other words, if the CPA had decided they were going to discriminate based on religion or race, if they were even going to enslave the Iraqis, then would there be any constitutional barrier to that? The answer seems to be no. There's no constitutional barrier whatsoever. If they wanted to take ordinary Iraqis who were committing kind of petty crimes and torture them or kill them, would that violate the Eighth Amendment? And the answer would seem to be no, because there is no Eighth Amendment claim that they can bring. Hard to believe. Likewise, this position would suggest that we could take the tens of thousands of non-citizens in our penal system, right? So we have lots of non-citizens that have been arrested for drug crimes, for all kinds of crimes, and we could just move them offshore to a kind of, to a prison, much like these prisons we were talking about earlier, outside the boundaries of the United States. And again, we don't have to worry about the Eighth Amendment. We don't have to worry about labor laws. We don't necessarily have to worry about any constitutional laws at all. We could torture them, we could kill them. We might have to worry about international law, we might have to worry about political law, we might have to worry about statutes that reach these issues. But as a constitutional matter, we're totally unfettered. We could do whatever we want to them. Again, that seems hard to believe. But that is the necessary conclusion from the position that the Bill of Rights stops at the border for aliens. And again, you have to ask yourself, why for aliens and not for citizens, right? What is it that explains that? We once had a coherent position, now we don't. Okay, so let me talk about 3 ways to think about this, and then we can discuss this more. So one way to make sense of all these issues is to say, why don't we have a pure territory approach? Why don't we say that the Bill of Rights and our legal system generally applies only within our sovereign territory and not anywhere else, right? Only within our sovereign territory, not anywhere else. We sort of had that position at one time. The problem, of course, is that in a globalizing world that's more interdependent than ever, it's very hard to make sense of that, right? You've got, as I said, simple things like cartels abroad, you've got terrorists abroad, etc. And so you've got Americans going abroad. So it becomes dysfunctional in many ways to have a kind of pure territory approach. People move across borders, right? We used to do this with the states internally in the US. We used to have a much more territorial approach to law, and increasingly we said, well, we can't focus on, sort of just location. We have to think about other things because people are moving all around, right? So think about long-arm jurisdiction. Think about a case like international shoe, right? So go back to civil procedure, right? So why we say, well, you kind of enter something into the stream of commerce, or maybe that's after international shoe, but we sort of move towards this direction of saying we can't just focus on location because we're a national economy. We're a large nation where people and things move a lot. So unsurprisingly, we've moved away from pure territoriality. So what about the other sort of extreme? What about pure membership? You could imagine a system in which we said the Bill of Rights applies only to citizens on a kind of social contract theory, right? So only to those who are members of our national community. So in other words, aliens who are here, foreigners who are here, don't enjoy the Bill of Rights, right? So you're from a foreign country or you're a foreign citizen, you're here, but we're not going to respect your rights in the same way that we'd respect your rights as a citizen, right? So, because it's about membership, and if you want to get those rights, you should become a citizen, right? So we can imagine that kind of system. We might even be more extreme and say our laws don't apply to foreigners at all. They only apply to members of the group. Right, this is kind of like if you think about the bylaws of a club, right? They sort of operate that way. So if you join, the International Law Society, and you have a set of rules, those rules don't apply to people who aren't members of the society, both in good ways and bad ways, right? So if you've got positive things like you get to go to, a talk, or you get, certain privileges, or negative, maybe if you make, or if you break certain rules, you get kicked out, right? None of that applies to people who aren't members. So that's a kind of pure membership conception. Does that make any sense? Well, no, it doesn't really. That wouldn't really work. Obviously, we need to, if we have foreigners here in the U.S., we have to have our penal laws apply. We have to have our regulatory law, or, sorry, our criminal laws apply, our regulatory laws apply. And moreover, for at least the last 100 years, we've had the view that foreigners in the United States enjoy all the same constitutional rights that Americans do, right? So it doesn't really make a difference. So we'd have to overturn an enormous array of precedent. So that seems obviously like kind of untenable. So you've got these two extremes. And then, of course, you've got our kind of schizophrenic position today that I've described, where we have a kind of uncertain conceptual underpinning for how we view the reach of the law. And so what I propose is that we instead think about the Bill of Rights as not having any, as being non-territorial, right? So rather than pure territoriality, think about it as a kind of non-territorial or non-membership. In other words, it applies to the government all the time, but we can temper this with a kind of rule of reason or a kind of pragmatic approach to say, well, in some cases, it's going to apply somewhat differently depending on where things occur. So for example, even within the US, when you're at the border, let's say you're coming off of a plane or you're crossing over from Tijuana into San Diego, the Fourth Amendment is understood to operate differently, right? It's understood to operate differently. When you go through screening at the airport, you can get a pat-down search. They don't need a warrant for that, right? The understanding is, well, there's special circumstances. You're getting on a plane, it's very dangerous. If we demanded a warrant for everyone being checked out, it would not work, right? So we make these exceptions. Likewise, a car coming over the border from Mexico can be searched under a looser standard because we understand the border is a different place, and the border, for this purpose, the border exception extends in several miles. So it's not to say that we should think about the Bill of Rights as applying everywhere all the time in exactly the same way, but instead think about it as generally applying as a kind of presumptive matter, and then we'd have to defend why it might apply differently, right? So this is the position I think we ought to take. I think it's the one that makes the most sense. So again, I'll call this kind of a non-territorial approach. So how would this work in practice? Well, so take the example of Miranda warnings. We normally read Miranda rights to everyone who is arrested or interrogated by the police, citizen or alien. We don't ask about their citizenship when we read them their rights. Should we do the same thing abroad? So the position that I'm espousing would say, yeah, we should. If the FBI is operating abroad, they should read Miranda rights in the same way. Now, do they have to supply a lawyer, right? So in the US, we'd say, okay, we're not going to continue if we can't supply a lawyer or so forth. Well, we might have to modify that because we're operating in a foreign legal system. We don't have a set of public defenders around. We don't have the kind of panoply of lawyers that we have here. So just like the border exception in the Fourth Amendment, maybe we have to adjust that. But the point is, if we think about the Constitution and the Bill of Rights as being restraints on the federal government, then it isn't obvious why those restraints should evaporate simply because the FBI agent got on a plane and landed in London instead of New York. Another way to think about this is we don't think about constitutional powers as stopping at the border, right? So go back to Ross v. McIntyre. When the Supreme Court said to Ross, you have no Sixth Amendment right because the Constitution cannot operate in another country, it's obvious that the judicial power was operating in another country, right? He was tried and convicted. So what they said on its face was wrong. Right? It can't be the case that the Constitution has no operation in another country because he was tried by an American court and convicted and sentenced to death and ultimately killed. So that on its face seems strange. Likewise, we don't think that the president stops being the president when he leaves the United States. We think he can issue executive orders when he's abroad or even in sort of international airspace if he's on Air Force One. He can't suddenly start handing out titles of nobility. Right? The Constitution says you can't hand out titles of nobility. Well, if we thought that the Constitution stopped at the border, then we would say, well, he's free to do any number of things. We don't think he loses his power. If the Senate suddenly decided to hold a session in Mexico, do we think they couldn't pass a law? I mean, that's unlikely to happen. But I don't think we believe that the Senate suddenly loses its powers when it leaves Washington, D.C., or for that matter, leaves the borders of the United States. So we've never thought about powers in that way. And I think the reason is because we think it doesn't make any sense to think about powers that way. So then you have to ask yourself, if that's true, why should we think about the restraints on those powers? And again, the logic of the framing was, We're going to grant certain powers, we're going to restrain them in a certain way, we're going to check them, we're going to balance them, we're going to separate them, etc. But we're going to create an overarching system of governance that's meant to be limited by definition, right? It's not a general government, it's a government that has enumerated powers and has certain restrictions on them. So all I'm really saying is, well, where you are on one side of a line or the other should not affect how those powers operate. And likewise, they shouldn't affect the restraints that go along with them. Okay, so let me just close with one thing which is related to Guantanamo. So sometimes when this idea is espoused or people talk about Guantanamo, it muddies the waters, because one counter argument that you might make to this position I've laid out is to say, well, yeah, maybe the Bill of Rights should not stop at the border, but if we start doing that, then what if we went to war again or continued to fight a war, and we had lots of POWs, are they all suddenly going to have constitutional rights? And so now we're going to kind of constitutionalize warfare. And I think the answer to that is no, we're not going to do that, because warfare is different, right? In the same way that if we were fighting a war on American soil and we were invaded by another country, we wouldn't believe that just because the troops are here, the foreign troops are here, and we capture them, that suddenly they too have Fifth Amendment rights or Fourth Amendment rights. Their rights stem from the laws of war, right? They might, if they're proper fighting force, they'll fall under the Geneva Conventions. They might fall under international humanitarian law generally, human rights law, etc. But we don't think that there is a different set of rules because the war is occurring within the US than if it's occurring on somebody else's soil. So again, the point is that warfare is a kind of separate category, and we treat soldiers differently. Now, the current war on terror raises some complicated issues, in part because we don't have normal armies, and the battlefield, in essence, is everywhere. So this is a little bit of the issue in the Padilla case, or I should say the Padilla case. So Padilla is an example in which here's an American citizen, he's in O'Hare Airport, and he's captured there, right? And the argument is, well, he's an enemy combatant, and it doesn't really matter whether he's in O'Hare or Heathrow. It's the same thing, right? So we're going to face these questions repeatedly. So the only point I'm making at the end is just to say, you do have to disentangle the war context from ordinary policing. And really, mostly what I'm interested in is ordinary policing, but it obviously raises constitutional questions, even in the war context and the occupation, which I discussed earlier. If we went back to formally occupying Iraq, or if we invade Iran and occupy Iran, not that far-fetched, same kinds of issues. I would argue that the US government as an occupying force is subject to the laws of war, which specify what occupiers can do, but it's also subject to the Constitution because it's a creature of the Constitution, right? So there are certain things that a government entity cannot do. Now, you can debate whether the Coalition Provisional Authority was an entity of the US, but this has actually been litigated recently in a series of kind of mundane False Claims Act cases. And the position of the US has been, yes, the CPA is an instrumentality of the United States. It was created by Tommy Franks, the CENTCOM head. Jerry Bremer was appointed by the president, essentially, to run it. It was an instrumentality of the United States. So if you take that view seriously, then you'd say, well, there are constitutional restraints on the federal government wherever it acts, which is basically the position the Supreme Court took 50 years ago in Reed v. Covert. Seems to me that that should apply today in the same way. So I'll end it there, and I'm happy to, should I take questions? Or?
Yeah.
Okay, so anyone? Questions, comments? Yes?
So I just wanted to comment that while I like your argument, I'm not certain that the social contract theory is so logically untenable or bizarre.
Okay.
To extend the club metaphor, members have to follow the rules of the club when they're on the club premises and all that, and they can't do something without getting thrown out of the club. But most clubs allow people to bring in guests.
Right.
But while they're on club premises, they have to, if there's a dress code, they have to follow the dress code, et cetera, et cetera.
Right.
Or in general, you can say there's a different contract that we sign with people who are entering the country.
Right.
And that would seem to sustain the whole idea that members always get rights, they get the rights everywhere, people on our soil get rights, but no one else gets rights. And I was wondering how you'd answer that.
Yeah, no, that's an excellent point. I think that's right. I mean, it depends. So when I was kind of using that metaphor, I had in mind a club like, or a society like one you might have in the law school where there is no clubhouse, in essence, but it's purely kind of virtual. But you're right, clubs often do have clubhouses. And so there you could say, yeah, there's a sort of guest theory that we apply. And in fact, I think you can read a lot of the cases that way. So if you read cases about immigrants and they're even Verdugo, right, or a case like Eisentrager, right, Johnson v. Eisentrager, the Supreme Court talks about the idea that as the alien spends more time here and develops ties, then we accord more and more rights. Now, I think that's actually not true. I think the alien who comes here gets rights, receives most constitutional protections and rights immediately, right? So in other words, a tourist getting off the plane in, I don't know if this is an international airport, but let's assume it is, gets off the plane, the second they're there, once they leave the border zone, they're going to receive, the same Fourth Amendment protections against unreasonable search and seizure as I would. And there's no tie to speak of. But there are kind of guests in the way that you suggested. So I think you can read a lot of the cases that way. Now, the harder question is to explain, well, why is it that we think the club's rules, in essence, apply outside the clubhouse? All right, so let's say the club has a rule that says you got to wear a tie, right? Whenever you're on the clubhouse premises, you got to wear a tie. And I'm a member of the club, and I bring you along, and they say, hey, you don't have a tie on, you can't come in. So you go, you get your tie, you walk in. Now, once you leave the club, can the club still say you have to wear a tie all the time? We might say, you can imagine, I guess, a club that did that. You have to wear ties constantly, including the... But normally we don't, right? Normally we think that clubs and their rules sort of end in the same way. So again, this is analogizing the way we thought about in the 19th century. So when the guest and the member leave the clubhouse, they're both free to do whatever they want. So at some point in the 20th century, we decided that doesn't make any sense, right? Now, we weren't interested in rules like wearing a tie. We were interested in, do you have a right to trial by jury? But we decided that wasn't the case. And in part, we decided it for, in part it was the Cold War, right? So one thing I think that's very important in that context is why did the Supreme Court change its view on this? It changed its view on this in part because there were so many Americans abroad. Because in the Cold War, we were projecting force really for the first time in a very extreme way. We had hundreds and thousands of dependents of military service members abroad. And they were facing court-martials on a regular basis, right? There was something like more than one court-martial a day in the 1950s of a non-soldier, of a dependent. So there was a serious issue about numbers. But we had the view that the Constitution is not just a set of rules about a clubhouse, but instead something that constitutes what the club itself can do, and that shouldn't be limited in some way. But I completely agree with you. I think there is, it's fair to say, and I think it's actually the best kind of defense of the current system to say it's something like a clubhouse, and that guests ought to receive a slightly, they receive special treatment when they're, or like someone in your home. You bring someone into your home, and you might sort of treat them in a similar way than as you would someone in your family. Right? I think that is a fair reading. So, yeah.
I had a question about the treatment of aliens abroad. The Bill of Rights, were you saying that there should be some Bill of Rights protection for aliens abroad as well?
Yes. I think again, we shouldn't have a kind of bright line rule that says they have no constitutional protections. I think we should think about it in the kind of functional way that I sort of described in terms of how we think about it even here, right? In terms of the border exception or other examples, we should say, well, what's reasonable under the circumstances, and not simply just invoke the idea, well, they cross this line, they lose all their rights altogether.
But in the application, in the absence of a bright line rule, then is there a presumption that it applies like where on the spectrum is it like the reasonable fact? I just wanted to ask you to expand on the functional.
On the kind of functional, reasonable, pragmatic side. Yeah, I guess my sense is, so for example, I gave the Miranda example. Think of another one. Imagine that we set up courts much like we had in the 19th century, these kind of extraterritorial courts. And they weren't involved in adjudicating cases related to the laws of war, to terrorism, but instead, or better yet, go back to the Iraq occupation. It's an easier one, right? So what could the CPA do in Iraq? I would argue the CPA is constrained by, or ought to be constrained by, the Eighth Amendment, the Sixth Amendment, the Fourth Amendment, the First Amendment, et cetera. Now, understanding that, we might bend some of those things under certain circumstances. So we might say, we're occupying a country pursuant to a military conflict. And maybe a country like Iraq is divided religiously in a pretty profound way. And so maybe we have to favor or disfavor certain religious groups or racial groups within that country as a way to keep insurrection down or keep the peace or something like that. But the point is you'd have to make that case. So I guess all I'm really suggesting is if it were litigated in some way, or regardless, the CPA would have to, I think, in its own kind of mind, its own deliberations, would have to say, well, can we make this case that we have to bend the First Amendment a little bit, right? So we're kind of First Amendment absolutists in the United States, free speech absolutists compared to most countries, right? So we think hate speech, basically fine. Maybe we'd have to be more restrictive on hate speech in that kind of context. But the point is, it's quite different to go from that to saying the First Amendment simply doesn't apply at all. And we can say, Christians, you get all the food. Muslims, you get nothing, right? That's the current position. And to me, that just seems normatively unattractive. And it seems at odds with what I think the spirit of the Constitution is, which is to create a limited, restrained government. Go ahead.
I just want to clarify, the burden of proof is on the party, or the government trying to, so
Yeah.
these are exceptions to the presumption that it applies in full.
Right. I think you have to be flexible about it. And I think, and again, I mean, this is a very kind of loose suggestion, so we'd have to see in particular cases. But I think what I'm arguing against is the kind of highly formalistic claim that it all just comes to a crashing halt the second you cross this line. I think that's neither appealing nor sensible. And how you actually implement a kind of more flexible, how much deference we should give, for example, is a harder question. And that's what courts are good at doing over time, is figuring that out. But all I would say is that's the way we ought to frame the inquiry, rather than saying there's no inquiry at all. What else? Yeah.
And does that work both ways for other countries that have bills of rights coming to the US? Would they also have some degree of respect for their bill of rights from their country while within the territory of the USA?
Well, if it's involving their own government, I guess that would be, so what I'm saying is, okay, so imagine someone comes from Japan and they're here. So you have a Japanese tourist or a visitor or a law student or something. And the Japanese police come over here and arrest them for some crime they committed in Japan. I mean, obviously the Japanese police have to, typically that's done under, they don't just sort of arrive on the plane and, there's arrangements that are made. But how the Japanese Constitution applies to that, first of all, I have no idea how it does. But I guess my view would be, yeah, I think as a matter of a general statement about how I think liberal states, liberal democracies ought to operate, I think it's probably the case that I would probably say, yeah, all liberal democracies ought to have a similar rule. But I haven't really given this any thought. But it certainly doesn't affect the American Constitution doesn't affect that in any particular way, except to say we don't allow murders to occur. Just because the Japanese police are here going after a Japanese student, they can't just kill them, right? I mean, our laws are applying all the time within our territory. But I think it's generally hard to sustain or to defend a rule that said territorial borders are, sort of bright lines that stop rights or constitutional provisions from moving around. But I don't know enough about other countries and their constitutions to really say. Is that responsive? Yeah.
Thank you.
Yeah.
You've been talking in terms of the Bill of Rights as restraints on government. And so the vehicle that carries this Bill of Rights outside of our borders is the state entity, whatever that may be, the U.S. police officer.
Acting. Right.
But there's another way to think about it, I guess, which is that the Bill of Rights is a set of positive rights conferred upon the individual to enjoy those rights, and maybe they're all correlated, and perfectly so, with the restraints on the government. But if you thought about the individual as the vehicle that carries the rights outside of the border, you'd have a different situation. Now, maybe it doesn't really work. So I go to France, I have to be acted against by a U.S. state, the state in capital S, right. Entity before my Bill of Rights kick in. the French government isn't constrained by my Bill of Rights.
Correct.
Um,
Correct.
I just, so taking the flip side of this set of rights, maybe it's the exact same thing, but I sort of wonder in the CPA context, for instance. The CPA is constrained by this Bill of Rights. Do the Iraqis under the sort of control of the CPA enjoy automatically their own individually held rights, or is it only the correlative
Yeah,
rights of
I think
the
it- I think-
restraint? And then this Japanese example, presumably this person has the territorial argument going for him that not only can't the Japanese cop murder him on U.S. soil, but in addition, he enjoys the entire Bill of Rights while here. So, in
Well, but he
addition,
wouldn't-
perhaps to the Jap. I mean, and those aren't exactly the same Bill of Rights, and so maybe he has a double Bill of Rights when he's acted on it on U.S.
No,
soil
I don't
by
think he
Japanese-
does. I don't think he does. So for example, let's say that I searched your bag right now, and you said, "What are you doing?" You know, and I said, and then you tried to take me to court and say he violated my Fourth Amendment rights.
You're the state.
No, I'm just me,
Okay.
right? You'd have no claim, right? I'm just a person, you're a person, there's no claim whatsoever. Likewise, if a Japanese police officer, either here on vacation or here in an official capacity pursuing some, criminal investigation, were to search your bag, the same issue, you wouldn't have a Fourth Amendment claim against them. Now, if they were working, I don't know enough about the details of this, but I'm sure that if they were working in collaboration with the Durham police, right? And so they worked together, and they would, then there would be some kind of state actor. We'd say that they, were operating under the aegis of the police or something. In other words, we wouldn't want to create incentives in which the police could just get like a Japanese officer on a ride-along, and that would kind of immunize them from anything that they did, because they could have their Japanese friend do all the talking and shooting and searching, right? So obviously but if they were here on their own, you wouldn't have any claim. So likewise, so in your Iraq
I have a
example.
claim under the Japanese Constitution.
Yeah, you might.
Argument.
You might.
But you sort of brushed over this intergovernmental
Okay.
agreement for exercising state power on somebody else's territory. I mean, that's actually critical, and it happens all the time, and it's a very important agreement that I'm sure would impact this argument. So you're talking really about some of the weirdo situations where there's no other state control. Like
No, I don't think they're. Take the example of the FBI going abroad, or the New York City Police Department that I talked about. They do have agreements with local. They don't just show up and wield their badge, and they make arrangements, and it's officially sanctioned. I would say that doesn't make it, whether they're there under the, with the approval of, let's say, the Israeli government they're operating in. So New York City has at least one police officer stationed in Jerusalem or Tel Aviv. And the Israeli government knows about it and approves it. Does that change the calculus in terms of thinking about whether they're restrained in some way when they operate against Americans or foreigners? And I would say it doesn't really make a difference. It wouldn't make a difference whether they were there with approval or not with approval. The point is, they're a government actor, and they're operating with the authority of the U.S. government, and they're wielding U.S. law, right? They're not trying to enforce Israeli law. They're trying to enforce New York City law, New York State law, federal law. In the case of the FBI, federal law. DEA, it's federal law. And so, the bitter and the sweet would go together. So in other words, if they're out there saying to foreigners that they are subject to our laws and we're going to enforce our laws against them, all I'm saying is it shouldn't make a difference whether they're on this side or that side of the line, right? And so the approval issue, I think, is a kind of red herring. Does that make sense?
Again,
Or at least I don't see why it should matter. I mean, if you can make the case for why. Did you want to follow up on that, or?
Yeah, I was just wondering why, if the U.S. is going to give approval through any sort of agreement to another country to conduct its law enforcement operations here, why our government wouldn't be required to include in that agreement certain requirements so that the actions are consistent with the Bill of Rights, whether you consider that an entanglement.
Yeah, I don't know. It's an interesting issue. Empirically, I don't know what we do, and that's actually something that I'm interested in finding out. I assume that when we do have foreign police officers or investigatory officials here doing some kind of investigation, that one, it's pretty much almost always under some kind of arrangement, pre-approved, and two, that we do have some restraints on what they can do, but I have no idea. So if a French officer is here interrogating a French citizen or another, some third-party citizen, I can't imagine they have to read Miranda rights. But
Even so, that the
I don't
remedy
know.
would be only in U.S. courts for exclusion. It wouldn't apply to
Exactly.
French courts.
So for that reason, I really doubt that that's the case. Now, it's a matter of French law or Japanese law, depending on our example, but that's my assumption. Did you want to add anything more?
No, I'm not sure what I would add. Yeah, it's interesting.
Other questions? Yeah, in the back.
I'm just wondering about going back to the aliens abroad issue and how
Right.
many problems that arise there with one who is an alien abroad. Like I'm a foreign student, for example. So if I'm a foreign student while I'm in America, I am an alien. But once I leave, I'm a Canadian citizen and a Romanian citizen. I no longer have any connections to the States until I re-enter and renew that visa.
Right.
So if I go to France, I'm interrogated by an American police officer. So not only, I'm not sure whether or not, how they would decide whether or not I was an American alien, or how do you deal with the conflicts of problem? Who should be protecting me? Should it be that I should get rights from the States, or should it be that I'm getting rights from the Canadian government that is stepping in to protect me against violations of the Bill of Rights or violations of the Constitution?
Well, first of all, I think, so you're Canadian. So let's say you go to France, and it turns out that you're part of a drug smuggling ring, and you've been smuggling narcotics into the U.S. And so the DEA tracks you down in Paris and arrests you and interrogates you and so forth. So the Canadian government might interpose itself, right, to protect you. And likewise, if it were reversed and it were me and I was in France and it was the Canadian and I had been smuggling narcotics into Canada, I might be able to get some diplomatic protection from my state, right? Probably not very much in that kind of circumstance, but it's possible. That's a separate issue. That's about states protecting their nationals, and that's a common thing, right? States will sometimes interpose themselves, sometimes not, and it's treated as a kind of diplomatic matter. But in terms of the Bill of Rights issue, so what's Canada going to do in that circumstance? Well, I guess it's conceivable that the Canadian government could complain and say, wait a second, DA, you're interrogating one of our citizens, but you didn't have a proper warrant to search her bag or something. That seems to me a really implausible. I mean, it's part of the same idea of, there is often diplomatic protection that's offered. I can't imagine it would come in that form, but I guess it could. But I think the U.S. government's position would be, first of all, the Canadian government, can't make the claim. It's got to be the person. And anyway, the non-citizen, don't have any Fourth Amendment rights to begin with, so it's a moot point, they would ignore it. So, the issue really becomes between you and the American government, right? Can you bring some kind of claim against them? Do you have any kind of rights? And again, it's just say it's easy it's easy to have these kind of complicated hypos, and it can all seem kind of murky and confusing. I think the easiest way to imagine it again is just imagine you're on one side of the U.S.-Canadian border or the other. You're in Windsor, or what's the town on the other side? Okay, and you step over. Does everything change because of that?
Well, if I'm Canadian, sure.
Well, yeah, but no, vis-a-vis the American government. So same scenario, you're a drug trafficker or whatever. If you suddenly manage to leap back to the other side in the midst of the interrogation, do they suddenly have to stop and get a lawyer and do all that? And does that make sense, right? Why would we want a rule, or why do we think that there's some kind of like force field? Again, if we think that it comes back to what's the point of the Bill of Rights? Well, the point is, maybe it's his answer that the point is to protect the club and its guests. And when you jump back and forth over the line, you're jumping back over the line between guest and total outsider. That's possible. But if we think it's to restrain the government generally, and again, we'd have to ask ourselves why we think the clubhouse border is significant, right? I mean, why should it be significant? Go ahead.
So, I mean, in that hypo, what is the difference between a guest on the wrong side of the line who just becomes a nobody and just a foreigner? Do we have to extend the Bill of Rights to foreigners in general if we're having a hard time defining aliens as it is abroad?
Well, I don't think we have a hard time defining aliens abroad. An alien is anyone who's not a U.S. citizen. I think that's easy. It's easy to know you're not a U.S. citizen, you're an alien. You're an alien here, you're an alien there. You're always an alien, right? Until you're a citizen. So that's a pretty simple line. The question is just how do we treat you and why should we treat you differently. So for example, we might say, since you're an alien, we can treat you however we like when you're here, right? Nothing, I mean, obviously there's a whole international law overlay we're kind of ignoring. But let's imagine that we don't care about that, right? Or that that doesn't exist. Constitutionally, the Supreme Court for a long time has said, we're going to treat the alien like a guest. We're going to treat them exactly the same way. But there's no, again, why, that's a sort of choice that we make. Is that constitutionally, in some deep sense, mandated? Why do we think it matters whether you're in the clubhouse or not? I mean, we could have a rule that said you can't have any guests, or guests have a different set of rules. But we traditionally have not done that, in part because I think we've had this implicit idea about guests, and we've been an immigrant nation, and so we've wanted to be welcoming. Yeah?
Your argument, though, seems to have a degree of paternalism to me because, taking the Mexican case, we go over and we say, okay, we're not going to afford you our Bill of Rights. But I don't know if there's some sort of intergovernmental agreement that will respect the Mexican equivalent of the Bill of Rights, when we go over there. So then, in a sense, it just seems like we're saying, well, and I don't know, maybe there is no agreement, but your Mexican Bill of Rights or your other Bill of Rights isn't good enough. We've got to also restrain ourselves. I mean, maybe there isn't that comedy there, but.
I see what you're saying. I don't think that's a problem for the following reason. I think the issue is, so in the Verdugo case, the issue was the U.S. government was trying Verdugo for violations of our laws. His house and the important records and evidence happened to be in Mexico, right? And so the issue really was, here's one way to think about it. Would you want to have, so imagine Verdugo is being interrogated, the drug trafficker is being interrogated. Would it be okay for the FBI to drive him across the border in order to interrogate him more aggressively, right? And so all I'm saying, there's nothing paternalistic about that question. It's just about, does it suddenly open up possibilities, right? So if you took the current doctrine seriously, you'd be able to say, why don't we take every foreigner that we arrest and fly? This would be expensive, but why don't we fly them all over the border or walk them across the border into Canada or Mexico? And then we have a free hand. We don't have to worry about, in fact, why don't we pick up their stuff that we want to search and move it across the border too? And then we could search it willy-nilly however we want. We don't have to worry about any of these. So the paternalism thing, it has nothing to do with Mexico except that the information that we desired happened to be sitting in Mexico. But that's sort of contingent because you can move things around, right? So I don't think it's getting at, if the Mexican government wants to arrest him too for something that he did, well then that's a different story and you might have a kind of conflict between the two countries over who gets to try him for what and how. But if it's just an American agent, FBI agent, DEA agent, that's crossing over the line and going into Mexico, again, I would just say, why should it make a difference where that interrogation takes place? And if you think it does make a difference, then doesn't that incentivize law enforcement to actually go and move people across the border, maybe even to torture them? Right? Do we really think that's?
I guess my question stems from, if it would be dependent on whether there's intergovernmental agreements that when you go into the Mexican border, you have to respect Mexican laws. Like if the Japanese,
Right.
scenario, if the Japanese police came into the U.S., they have to respect U.S. laws. So that's why I'm saying that you wouldn't just bring him back over the border to torture him, because presumably there would be a Mexican law that would say you can't torture people,
Right.
So that's what I'm just trying to say, is that once you
What if we took them to
put
the high
these
seas?
restrictions on our government unilaterally, but is it saying, because we don't trust these other governments to protect their own citizens or to protect people within their borders?
I see what you mean. Well, first of all, you're right. You could, so the Mexican government might say so the DEA operates in Mexico a lot, right? Because there's a lot of drug trafficking through Mexico. And again, I don't know the precise nature of these arrangements that are made, but I assume that DEA agents are held to be, they're in Mexico, and so they have to follow Mexican law. Now, as a practical matter, they're U.S. DEA agents, so they're going to have a lot of latitude, right? The Mexican government is going to give them a probably pretty wide berth. But as a formal matter, yeah, they have to follow Mexican law. But of course, they can break Mexican law And so the issue is they have the ability to break it in the same way that we all have the ability to break the law. We just suffer consequences. And so is there an added degree, is there an added restraint that emanates from our legal system? And maybe it's easier to think about this in terms of the high seas, right? So imagine that instead of taking a suspect and flying them or walking them into Mexico to interrogate them, we take them out 12 miles out to the high seas, to international waters. Should we say then that there's an entirely free hand? There's no other sovereign, there's no other national legal system.
Your argument, but I just thought that there's some degree of, but I think you're right in the application practically.
Yeah.
That, since they are going to have a wide berth but presumably you would assume that Japanese police coming in here wouldn't necessarily have a wide berth about what they could do with it.
No, obviously the U.S.-Mexico context is very different than the Japan-U.S. context. Let me also just point, just as a doctrinal matter, we tend to be, so take something like the Fourth Amendment. Our Fourth Amendment jurisprudence is much more rights protective of defendants than most other countries, right? Likewise, our First Amendment is much more rights protective. So in many ways, yeah, it's true that there's an overlay of foreign law that might exist that might constrain what our officials can do. But in many cases, it's calibrated at a level that we don't think is appropriate, right? As a society, we've decided that we should be very protective of privacy rights when the police go and search your house or home. And other countries have slightly different rules. So the real issue is just, do we want to go? Yes, that provides a kind of backstop, but in many cases, it's not where we would want it to be. And should we just slide to that level, or should we have an additional set of constraints? So you're right, in a certain sense, it could be read as paternalistic. I see what you mean. Anyone who hasn't? Yeah.
This has to be our last question.
Okay, well,
okay.
in danger of flogging this one, the dead horse here, the vehicle of these Bill of Rights, I think, is still important. This hypo, I think this hypo about stepping across the border, that was the alien individual who benefits from the rights, stepping across the border, do the rights disappear, they still there, do they disappear? Most of what you talked about was the state taking the restraints upon it outside of our territory and still being restrained by those restraints.
Well, it's two sides of a coin.
Well, it is two sides of a coin, especially when they're symmetrically applied.
Well,
Right? And here's a,
Well, just think about take the Fourth Amendment as an example. The Fourth Amendment doesn't say police or agents of the U.S. government cannot search unreasonably. It says the people are, again, I forget the exact wording, but it's couched in terms of we have a right to be free of unreasonable search and seizure, right? So, but in practice, what does that mean? It means that when a
can't search and see.
Yeah.
And I appreciate that. I guess that just in conceptualizing it, it matters which entity is going outside the border with these rights. And here's a question. I see in what you've described the potential for a divergence where in Utah, the person who holds the rights doesn't get them, even though they're in the territory. And the state who is restrained by the rights isn't restrained when they leave the territory. Territorial application, the latter case, non-territorial in the former.
Right.
Very state-friendly scenario where the rights, the power of the Bill of Rights basically dissolves at both ends of that equation. But I don't know if that's...
Yeah, no, I think this is, I think several people would look at this Utah case that I mentioned as an example of this kind of sort of slippery slope, or why the Verdugo decision is dangerous, because it gets away from this kind of guest idea and says, in essence, it's as if, I guess the analogy would be, this person is not a guest in the United States. He's rather a thief or a kind of intruder, right? He's here illegally. He comes in and breaks in through the kitchen of the clubhouse, and then we find him here. Do we have to treat him as a guest? And the court says no. Now, that's a major break, because we've always had the view, because we had such a strict territorial view in the past, we had the idea it didn't matter how you ended up in the clubhouse. As long as you crossed the line, you were safe. You sort of received all the things that club members did. So now if you go down this road of deciding, well, who's really a member and who isn't, especially in a society as fluid and as immigrant heavy as the US, that's a really revolutionary kind of break. Now, I have no idea whether that decision will be, it may have already been overturned. I have to look. It's at least a year old or more. But it's a revolutionary kind of break for that reason. So, are we out of time? Okay.
Thank you.
Thank you very much. Thanks.